So now we are going for question number 2A. Again it was asked for 7 marks. So see, Rumi went to a renowned furniture showroom named Trends in Delhi in Kirtinagar for the purpose of customizing and mixing a sofa in her office cabin. So of course Rumi went to showroom to see one sofa which should be fit for her office purpose. Within 30 minutes she finalized one design which suited her office cabin, color scheme and space. So she have chosen one sofa as per the color and theme of the office. Mr. Parth, who is Parth, owner of this Trend in Delhi, it means he is owner of the showroom, assured that he will deliver the sofa within a month. So he said that he will be delivering the sofa within 1 month. Mr. Parth told her that sofa will cost 45,000 rupees and will charge extra 4,500 towards cartage and corporate packing. So Parth said that the cost of the sofa is 45,000 and he will be charging 4,500 rupees extra. For what purpose? Cartage and for corporate packing, nothing but for packing and delivery charges 4,500. The amount of 4,500 towards cartage and corporate packing must be paid by Rumi at the time of delivery of the sofa, and the remaining amount may be paid within a period fixed for approval of the transaction. It means this 4,500 packing and delivery charges you have to pay at the time of delivery only, and remaining amount of 45,000 rupees you have to pay after the approval of transaction. It means this is the sale of approval basis here, sale on return basis or sale on approval basis case. He also assured Rumi that he will be responsible for assembly and installation of the same without any causing harm to her office cabin. So Rumi was assured by the seller that he will be responsible, Parth will be responsible for assembly and installation. Means he said that I'll assemble, I'll install the sofa in your office without damaging your office, which is situated in the 9th floor of the building at no extra cost. So here what happened, Parth said that he will install on the 9th floor at no extra cost. Rumi agreed with the terms and condition of Mr. Parth, but with the condition that she will not approve the sofa and return the same if it will not be perfect according to the size and color described. So she said that boss, as of now I am accepting the terms and conditions, but I'll buy the sofa only if it is fit for my purpose, you can say here. Okay? Mr. Parth agreed to his condition but fix the maximum time by which Rumi can reject the sale, that is 20 days. So Parth said to the Rumi that you can see whether it is fit for your purpose or not, but within 20 days either you have to accept or you have to reject after delivery. So these 20 days will start after delivery and installation is over, which Rumi also agreed. अब देखो क्या हो रहा है. As per the schedule, means as per the date which they fixed, Mr. Parth sent the sofa to Rumi's office. अब देखो क्या हो गया. Mr. D, who is the employee of showroom person Parth, denied delivering the sofa at the 9th floor by stairs. He said that I'll not deliver this sofa by climbing to the 9th floor by stairs, as it was not accommodating in the service lift. So they said that we agreed to install, but it is not fitting in the service lift here, so we have to take the sofa by the stairs, and for this purpose you have to pay some extra amount. So Rumi paid employee, that is Mr. D, 1,500 to deliver the sofa at 9th floor by stairs. After assembly and installation, she paid 4,500 rupees for cartage and corporate packing as mutually agreed here. So 1,500 rupees she paid for climbing, taking the sofa to the 9th floor, and 4,500 rupees for cartage, nothing but for packing and delivery charges. 1 month later, this one is important. See, what is the time period that they fixed? 20 days. But here what is happening? 1 month later, means after 30 days. When Mr. Parth asked for the payment of 45,000 rupees, after 30 days, that is after 1 month, Mr. Parth is asking for the payment. But Rumi said that she want to return the sofa, contending that it was not according to the size and description of her office as she had mentioned at the time of buying the sofa. So now she is saying that I won't buy this sofa if it is not fit for my cabin purpose. Alternately, so she's saying that she was ready to pay only 25,000 towards the cost of the sofa in the place of 40,000. So she's making one reverse offer, that instead of 45,000 rupees, I'll pay only 25,000 rupees. So either you take back your sofa or you sell me for only 25,000 rupees. Who is saying this thing? Romi auntie is saying this thing. Okay? As the sofa was not according to her choice and exact requirement. Analyze the applicable provision of Sale of Goods Act and advise on the following reason. Firstly, whether Romi can refuse to make the payment of 45,000 rupees by mentioning that sofa was not according to the size and description which she described at the time of placing the order. So conclusion is, can she reject the sofa or not? Answer is no, because you have time period of only 20 days, but you are rejecting after how many days? 30 days here. In your opinion, whether Romi was signified in her approval to Mr. Parth in any manner before the specified day of approval? Let us discuss whether Mr. Parth should file a suit against Romi for the non-payment, or he should accept just 20,000. Means, can Parth file suit against the Romi, or simply he has to keep the mouth shut and he has to accept that 25,000 rupees towards the full and final payment of the sofa, as there was remote chance of having a positive outcome of the suit and the sofa was customized and already delivered to the Romi, so no chance. Isliye whether he has to accept this 25,000 rupees only or not, they are asking here. So say provision. As per the Sale of Goods Act, where goods are sold by description, there is an implied condition that the goods shall correspond with the description. So of course condition has to description. Next, in sale on approval basis, the buyer is deemed to have accepted the goods when she signifies approval or does any act adopting the transaction or retain the goods beyond the fixed time period. Nothing but, sir, when ownership will transfer in case of sale on approval basis, when she accepts the transaction or when she does any act which will disturb the ownership of a seller, or if she fails to return the goods within the reasonable time or within the fixed time. Further, when the property in goods has passed to the buyer, ownership is passed to the buyer wrongfully neglect or refuse to pay, seller may sue the price. It means, if the ownership is already transferred to the buyer, then seller has the right to file suit against the buyer. Seller is already transferred the property to the buyer, so easily seller can recover the price. So see, Romi purchased a customized sofa from Parth with the condition that she could reject it within 20 days after delivery and installation if it was not according to the agreed size and color. The sofa was delivered, assembled and installed in her office. Romi paid 1,500 rupees separately for carrying the sofa on the 9th floor, and she also paid 4,500 towards packing and delivery. However, Romi raised objection regarding the size and description only after 1 month from the delivery, which was beyond the agreed approval of this 20 days here. Next, under sale on approval basis, retaining the goods beyond the specified time amounts to acceptance of goods. So if you fail to return the goods or if you fail to reject the goods within the time period, then it will amounts to acceptance of goods and property will transferred. Further, by making payment towards delivery related charges and allowing installation and use of the sofa, Romi had signified her approval. It means, sir, when she has let the seller to install and she started using the sofa, that to beyond 20 days, so it means she has accepted the transaction. Therefore, Romi cannot later refuse to pay the agreed price of 45,000 rupees, or unilateral, means from her side she cannot reduce the price to 25,000 rupees. Since the sofa was customized and accepted by Romi, Mr. Parth is legally entitled to recover the agreed price. So conclusion, Romi cannot refuse the payment of 45,000 rupees because she failed to reject the sofa within a period of 20 days and is deemed to have accepted the goods. So she cannot refuse the payment, she has to make the payment. Yes, Romi signified her approval, means yes, she has given her approval. How? By retaining the sofa beyond the approval period, I think beyond 20 days here, and by making the payment connected with the delivery and installation. Any of this packing and delivery charges is separately, or it's not a regulated part here, but main thing is you have retained the sofa for more than 20 days. Mr. Parth can file suit against the Romi for the recovery of the agreed price of 45,000 rupees and is not bound to accept 25,000 rupees as full and fine. Means he can recover 45,000 and he is not supposed to receive only 25,000. So this was all about this second question 2A. Now we'll go for 2B. Acha, in 2B they asked two questions here, like firstly this question and then they asked about this one also. Got it here? So first one is for 3 marks. Let us discuss this part here. Differentiate any 3 points. They are asking to give 3 difference between the equity share with DVR and preference share capital. As we have already seen the meaning of equity share with DVR holder. We have discussed in the classroom only that equity shares are of 2 types: equity share with same voting right and equity share with a differential voting right. Here the members are having different voting right. Either they'll have more voting right or they'll have less voting right, but they will have some kind of different voting right. Whereas preference shareholder, we have seen that they will have preference over the equity shareholder. Whenever company want to pay dividend, before paying dividend to the equity, company will pay dividend to the preference. And whenever company want to close down, at the time of closing down, they have to repay back the capital. So before repaying any single amount to the equity, first we have to repay to whom? Preference shareholder. This was the meaning we have seen. So say meaning, equity share issued with a differential voting right or dividend right or other right, means they are some kind of different right. Main thing is they have different voting right here. Next, preference shares, they are carrying preference rights over the equity shareholder with respect to the dividend and repayment of capital. Next, voting rights, shareholder may have different voting right, means they may have either more voting right or less voting right. Isliye their voting rights may be restricted also. It means less voting right. Voting rights are generally restricted in case of preference shares except in a specified matter. So as we have seen that, sir, preference shareholder cannot vote on all the matters. They can vote only on the matter which are directly connected with them, because they are not the real owners. What are the real owners? Equity shareholders. Got it? So preference shareholder cannot vote on all the matters. They can vote only on the matter which are connected with them. But however, we have seen if company fails to pay the dividend for more than 2 years to the preference shareholder, then they will also get right to vote on all the matters here. Next, dividend. Sir, equity shareholder. Acha, one more thing here. See, equity shareholder with same voting right, you have a differential voting right. Only difference is voting right, not a dividend. Got it here? So they'll have all other rights which are applicable to the same voting right person here. So coming to the equity shareholder, sir, dividend is not fixed and depend upon the profit and company policy. Sometimes they'll get more dividend, sometimes they'll get less dividend. Whereas preference shareholder will have a fixed rate of dividend here. Repayment of capital. Sir, equity shareholder, whether you are SVR or DVR, you will get the payment only after repaying to whom? Preference shareholder. Whereas preference shareholder get priority in the repayment of capital during the winding up. Next, risk factor. Sir, who is the real owner? Equity shareholder. Whether it is SVR or DVR, they are the real owner. Isliye they have a high risk. They have a high risk. Because sir, if company is performing well, then they'll get the dividend. If company is not performing well, then they'll get very less dividend or they may not get any dividend. And ultimately, they are the one who is running the company. Isliye, sir, they have very high risk. Whereas preference shareholder, they'll also have the risk but very less risk. So I have given here totally 1, 2, 3, 4 and 5 difference. But in the exam they ask only 3 points. So you can write only 3 points. That is also fine here. Got it? Chalo. Next, 2B, second point for 4 marks. They ask this question for 4 marks. Doctrine of consecutive notice. We have seen this in class many times here. Sir, whenever ROC issuing certificate of incorporation, so it is consecutive notice that company is incorporated and anyone dealing with a company should read the memorandum and articles to know the powers of a company. So this is what we are saying, that company is having a consecutive notice, means they have given a notice to everyone that whoever want to enter into contact with the company, they should read this memorandum and articles to know the powers of a company. So see, the doctrine of consecutive notice means that every person dealing with a company is presumed to have knowledge of contents of the memorandum and articles. Since these documents are public documents available for inspection with the registrar, or you can go to the company, you can inspect this at a very nominal fees. Therefore, any person entering into a contract with the company is presumed to have read this and understood this document. Even though you have not read this, still I will assume that you have read these documents. If a transaction is beyond the powers contained in the memorandum or articles, the outsider cannot claim that he was unaware of such a limitation. So before entering into the contract, read these documents here, so that you should know what are the powers of a company. You cannot enter any contract which is beyond the powers of company, ultra vires. Got it? Then I have given some example. So thus this doctrine protect the company against the outsider. So doctrine of consecutive notice is protecting the company against the outsider, dealing with it without verifying it public documents here. Got it? So this is about 2b second part. Now let us see 2c. Again here also we have two parts, question number 1 here, and then we'll go for question number 2. Let us see. Referring to the provision of LLP, discuss the powers of central government for issuing direction for taking corrective steps against the LLP being registered with a similar name of an existing LLP, company, or registered trademark of a proprietor under the Trademarks Act 1999. It means they are saying that, sir, if LLP is incorporated and later on central government came to know that the name of LLP is very much similar or identical with any other LLP, any other company, or any other trademark. So can central government pass the order to change the name of the company or not? This is what they are asking. Got it? Also discuss the power of central government to suo motu take steps towards the redressal of the above issue on persisting non-compliance of such a direction. It means, sir, can central government take action against you if you are not changing the name of the company? So already we have seen that if the name is similar, then central government will pass the order to change the name of LLP. You have to change the name of LLP. If you are not changing, even after receiving this notice from the central government, then you will be held liable. Central government can take action against you. So this is also direct question. We are writing the direct part. As per LLP, where an LLP is registered by a name which is identical or too nearly resemble the name of existing LLP, company, or registered trademark, the central government may direct the LLP to change its name. Such a direction may be issued on an application made by existing LLP, company, or proprietor of the registered trademark within 3 years from the incorporation or registration of the LLP. So means, sir, whoever finding that the name is similar, they can approach the central government that, sir, my name and this new LLP name is same. So you have to go to the central government within 3 years, that we have discussed. And then central government will give direction. So suo motu, central government, if it consider the name is undesirable or misleading. So it means, say, central government can issue this direction either on the request of whom? Either on the request of, I'll just name this one here. Okay, now you find, say here. So central government can issue this direction either after receiving application from these persons or suo motu, central government on their own can take the action here, can issue the notice here. The LLP shall comply with the direction and change its name within 3 months. We have discussed that, sir. Once the central government is giving you the order, you have to change the name within how many months? 3 months from the date of direction, and shall intimate the same to the registrar accordingly. If the LLP fails to comply with the direction within the prescribed period, means if you fail to change the name of LLP within 3 months, then central government has power to allot a new name to the LLP on their suo motu. The registrar shall enter the new name in the register of LLP and issue a fresh certificate of incorporation reflecting the changed name. Plus, central government can also take action against you. They can impose you the penalty. Thus, the act empowers the central government both to issue direction for rectification of name, and if you fails, either they will change the name on their own or they will impose a heavy penalty on you. Got it? So this was a 2C first question here. Now we'll see 2C second question here, which is for 3 marks. Out of the designated partners, at least one should be resident in India. So we have seen that in LLP, management of the LLP will be with whom? Designated partner. And we have also seen that minimum there must be how many designated partner? 2. At least one of them should be resident in India. We are not talking about the citizen of India. They must be resident of India. And we have seen that resident of India means they have to stay for at least 120 days. Elaborate upon the provision relating to the designated partner as laid down, further defining a resident partner as provided in the liability. It means they are asking about this point. What do you mean by this point? Explain about this point. And then they are asking what do you mean by resident person? When a person will be called as resident of India, we have seen that you have to stay in 120 days, not citizen of India. Citizenship of India is different and resident of India is different here. Got it? So you will be called as a resident of India only if you are staying for minimum 120 days here as per the LLP Act. So see, according to the LLP, every LLP must have at least 2 DP who are individual, means this DP must be individual, and at least one of them must be resident in India. A DP is responsible for the compliance with the provision of LLP Act and other requirement. Of course, the management of the LLP is with whom? DP. So they are the one who is liable for the compliance of the LLP Act and other requirement. If all the partners of LLP are body corporate, you have also seen that, sir. If all the partners of LLP is body corporate, means this LLP started by the body corporate, then they don't have individuals. So who should become the DP in that case? Sir, we have seen that they have to appoint any 2 individual as the nominee who will be acting as like a DP. Got it? Next, every DP must obtain a DPIN. Remember, designated partner identification number, and they have to give consent to act as a DP. As per the Act, LLP Act, resident in India means a person who has stayed in India for a period of not less than 120 days during the financial year. So you have to stay for at least 120 days here. Thus, the LLP Act make it mandatory that at least 1 DP should be resident in India. Minimum you should have 2 DP, and at least one of them should be resident in India. Got it? So this is all about this question. Second question, we completed the second one also. So 20 plus 20, 40 marks we completed. Totally we have 120 marks of paper. Because you have option, you have choice. I don't have the choice. I have to explain all the 6 questions here. So 2 are done. In the next video, we'll go for the third one.